Peace and love. We're back with part 3. So I'm reading from the website tribalgovernment.us. On the governance page, you can find the definitions that are being used in the lawful stance of the resurrection of the empire. These lawful terms are currently being used and being honored and you can go to tribalgovernment.us scroll all the way down you can even click here on courts. This is the official website that all international courts and governments refer to as far as what's going on in America and the de jure governance that has been resurrected. So we click here and go to courts. And scroll down. And you will see our royal decrees, excuse me, world notices. World notice of the sovereign soil tax. Let's take a look at that one. Let's see. Okay. 1 second. Okay. Text in the chat if you can see this. Doesn't look like it. Let me see. Can I share this world notice? This one, I believe, was written in 2018. 1 second, family. I'm trying to share my page. Okay. I'll share the entire screen. Let me see. Well, 1 second. Okay. There it is. Okay. So this is one of the legal notices that has gone out to all of the heads of state and governments, law enforcement, notifying them of the legal and lawful stance that we have under our seal, under our resurrected empire, and under our leadership. And this was resaved on mine. And it looks like it got transposed a little bit. Some of the seal is missing. But nevertheless, now know this, all men and women. Now comes Her Majesty in absolute Empress Ninti El Bey in Imperium status. Do give lawful notice, constructive notice, actual notice, the true bill, landlord demand. So these are the type of notices that I sent out to all governing bodies, officials, and those who are sitting in seats of power. So you can go to some reason this document got transposed. I'm gonna have to have someone change it on the website. So you can go to tribalgovernment.us and read more on the sovereign soil tax. Let me share this other screen as well so you can get a clearer picture of what is going on with our imperium and tribal governments. Okay. We also have a writ of assistance for our travel. This can be downloaded. This can be downloaded and used if you need it. Yeah, so this is when I started writing in all maroon. Let me make sure this is being shared. 1 second. I'll share the screen. Okay. So this royal decree is one of the ones that was issued to international courts, and basically it's just being in communication with them, letting them know um, what is going on in the governance here in America, so everyone will be on the same page. This is a notification in which they already know who I am as far as birthright and bloodline. So I'm just simply communicating with them, letting them know the stance that I'm taking and what should be the protocol. So the correspondence. This is a notification and mandate to aid and assist heiress Empress Ninti of the Empress's Six Royal Courts and the Aborigine of America in their travel using the newly launched American passport. This was sent to them in 2018, I believe. Let me see. I redacted this, so let's just continue on. All world travel associations and governments are hereby given notice of the American passport, and we thank you all in advance for your cooperation of unencumbered, free, and clear travel passage using our American passport for travel into all countries, ports, seaports, ports of call, airports, land checkpoints, toll booths, and international travel in general, as well as the free, clear, and unencumbered return back to America using our travel documents, which will be in the form of passport identification cards and or passport booklets created pursuant to ICAO standards and specifications with security features on par with all world governments and latest technology. So this is the letter. It's about 2 pages that can be found and downloaded as well on our tribal government website. And let me share other documents. So we also have a document here regarding the embassies in other countries. These are all U.S. embassies in other countries. So, being that we have lawfully brought back the de jure um, Americanist empire, these consulates, delegates, embassies are under our control, command, and under our empire effectively. Once the empire was brought out of interregnum, all those moving parts go back into the de jure power structure. So those that are sitting in those seats, in those embassies, and in different places of official capacity, they have to follow the de jure law, or else they will have the international community and Empress Ninti El Bey on their heads. Okay, so in the last part two, we dealt with Potomac Plan and some of the royal decrees and notices on our tribal government.us. There's a couple of documents that are here that can safeguard you in your stance on your travel. Okay. So this royal decree was written and issued to all and law enforcement all the way down in reference of our seal recognition and reference of our lawful stance when presenting our reclamation, our documents showing that we are of a certain status. This right here, this first part, the introduction states that as a notice to all Carolina constituents, and this was also sent universally to all governments, starting from Pentagon, Department of Defense, all the way down. So, notice to all constituents, empire, monarchy reestablished by an act of Congress in year 2016. The act of Congress solidified this proclamation and filing with the certificate number TXU 2-049-663. Refer to the Law of Ninti, Attorney Robert Adden, Attorney's Office. This decree is now considered law and shall be made a part of every legislature, judicial body, and law enforcement. United States Department of Homeland Security, U.S. State Department, Transportation Security Administration, State of North Carolina Governor's Office, Department of Transportation, and shall be added to North Carolina General Statute, Charter 20, Motor Vehicles, Article 1, Division of Motor Vehicles. Important. North Carolina General Statute, Section 20-403, shall be repealed and replaced with the summation of this royal decree, and the term autonomous and or autonomous vehicle shall only pertain to Aboriginal inhabitants who are autonomous upon the land, autonomous transporters, and autonomous conveyance. Decree of exemptions and immunities. Aboriginals of the land, Green versus State. All taxes, fees, and costs are exempted for the Cherokee Moors of North Carolina territories, inhabitants who are not at law considered U.S. citizens or state citizens or subjects of the state's policies, procedures, bylaws, show codes, etc. Yes, they still have chapters on the books treating people as G. If you don't have a status, you are subject to be placed in this category, unbeknownst to you and unbeknownst to your family members. Claim your proper status is paramount for seeking freedom. Aboriginals have immune and exempt status pursuant to the following references of law and antiquitous standing. These are some of the claims that I have made and brought back that were already there and that still stand for us today. Middle Plantation Treaty of 1677, Carolina's Charters 1663 and 1665, Treaty of Peace and Friendship 1786 and 87, Act of Congress, House Joint Resolution 75, His Majesty's Laws of North Carolina 1739, Proclamation of 2016, Ancient Imperial Moors are out of interregnum. Mind you, all of these participants in these treaties and charters and um, His Majesty's laws are of Asiatic descent, dark hue inhabitants who were ruling. Okay, again, here's my lawful definitions, letting them know these are the terms and the definitions that shall be adhered to and that will be used in further communications. And this is what they mean. Absolute law. Any law that follows the rules of nature, and a law that is changeless. It's an absolute law. So when you hear me say I am Empress Ninti El Bey, Her Imperial Majesty in absolute, that's what that means. That means that my bloodline is changeless. That's a law that no one can absolutism. Any system of government, be it a monarchy or a democracy, in which one or more person or class govern absolutely and at pleasure without check or restraint from any law. That's what I'm moving in. Okay. This is why there are those that have been ruling lawfully and been imposters and have taken the land. They don't like me. They don't like me because I do this. I live this life. This is what I'm here to do. So if you hear about me having challenges or me being arrested or me some having lands with the police, this is why. Because I do my job well and I make them bow down. And I'm fearless. So imperium means the right to command, which includes the right to employ the force of the state to enforce the laws. So you saw on my previous documentation, and in this one, it says Imperium powers, moving in Imperium powers. I think I got it up here. Yeah, Imperium. Those that know, they know what that means. I have the right to enforce the law upon the state and force them to act. The right to command, which includes the right to employ the force of the state to enforce the laws. Everything that they've been operating in is not the law. I'm bringing back the law. This is the law. The law of the ruling power ancestors, Asiatics, who were once upon the land, running every government from coast to coast and shore to shore. Heir of provision, heir of conventional. Now I know I'm a direct descendant of those who sat on the throne in 1913. So technically, this does not apply any longer. At the time I wrote, I was not aware of that truth. But I was still moving in their powers. Isn't that amazing? Who knew? So the proclamation is what we're standing on. the resurrection of the empire, the resurrection of an actual empire that existed in year 1913 is the powers in which I move in my direct family line. So this is the more pertinent and powerful to what I've always done and been doing for the last 20 years of my life. It is just icing on the cake for me. So this is one of the terms when you look at how we got into this situation of being with their foot on our necks. Unbeknownst to us, when the so-called powers that be came into power and there was no more agreement to have physical slaves. And when they came on the land, it was under the auspices of the land being abandoned because they ran the families off the land who were in the ruling power seats. So then after they ran them off the land, they said the land was abandoned. So all these years, approximately 107 years, we have been under, the governments have been running under the auspices of land abandonment. So that's why they've been on the land doing whatever they want to do and creating all these corporations so that they could have a way to move about in commerce, because that was in conformity with their original charters and their original commercial agreements. So they had to come up with a commercial way of doing things on the land when before it was just based on them having permission to dock their ships and do commerce on the water. So somehow they came up with the bright idea to create a corporate status. By that, they felt like, okay, we can use this to do what we need to do on land. Because remember, they didn't know how to really run governments or do business. These are um, individuals that really came out of a cave in the early 1900s, and they were deployed out to do the bidding of those 13 families that stole the empire and overthrew the governments of the world. So they needed a structure, they needed something for them, a playbook for these individuals to be able to function. They had to, it's like giving them a school book, follow this script. So they came up with the whole corporate system for them to be able to do business on the land. And that's where that came from. So this term right here, ab asudis non fit injuria, is a term that means from things to which one is accustomed, or in which there has been long acquiescence, no legal injury or wrong arises if a person neglects to insist on his rights. He is deemed to have abandoned it. And there's a case, AMB.645, 3 Brown, chapter 639. This is located in one of those old law books. It's early, maybe late 1800s or early 1900s that case was. But this is the auspices we have been suppressed with. We have been operating under the guise of abandonment. Abandonment of our status, of who we really are. We've allowed these people to give us corporate constructs as status, black codes, titles of black, titles of African American, Negro, black, colored. Negro, not so much, because that just means dark, like in Spanish, negra. But to be called black, to not to be recognized as black, it puts you in a certain status that is not to your highest and best good in a lawful sense. Because if you get caught up in accepting that, that means they can do whatever they want to do with you. And that's what's being done. That's what they've been doing for the last 100 years. Here, let me go back a little bit. So, here are some of the instruments that I have filed. Instrument is a document filed in the Register of Deeds. Heir of provision. This was my claim as heir of provision. And it says, one who succeeds as heir by virtue of a particular provision in a deed or an instrument. Abstract of title upon the land annexed and recorded within Mecklenburg County Register of Deeds, Imperial City, North Carolina, Cherokee Nation of Moors Territory. By the way, the entire state of North Carolina is still deemed, considered, and recognized by the governments in North Carolina and in America as being reservation territory, the entire state. North Carolina, Cherokee Nation of Moors Territory, instrument number 2010-095813, and book number 25836, page number 440, and ending with page number 444. Mecklenburg County Register of Deeds, Imperial City, North Carolina, instrument number 2018 020760, and book number 32481, page number 987, and ending with page number 997. Those numbers seem to follow me. By an act of Congress as of July 15, 2017, certificate number TXU 02, that should be 2016. That's an error on my part. It was filed in the Library of Congress as of July 15, 2016. Certificate number TXU 02049-663. Instrument number 2018 03415 2018 034135, book number 32548, page numbers 938 through 942. Those are all the claims under, those are all the instruments under my claim as heir of provision. Heir conventional. One who takes a succession by virtue of a contract. The provisions that I used in that are the Treaty of Peace and Friendship, 1786 and 1787. And this one is directly linked to me and my airline heirloom lineage. Carolina Charter, 1663 and 1665. That was King Charles. Proclamation. Ancient Imperial Moors are out of interregnum at filed at the Library of Congress under TXU 2049663. And again, we run into this term, absolutus non fit injuria. You all need to know that this is what they have placed us under. It's like they've all been in this secret society of knowing, and the rest of the population has been on the outside and not knowing anything about the business that's being done on us. It's a whole business behind what they have been doing with the people and subjecting them to the things that they've been subjecting them to. They've been, unbeknownst to the people, placing the people in chattel situations. Like when you go to jail, you are placed in a chattel situation. You're chattel property. Now they're using your identity without anybody to contest it. They use your identity anyway, but it's better for them to put a person in jail and don't have the have to worry about anybody contesting them using their identity. So they using your identity all up and down when they put a person behind, when they incarcerate someone. They're using everything, using the birth certificate, filing 1099s on your name with the IRS. That's money. That's a charge. A 1099 is a warrant. So they've been doing commerce with us and committing identity theft with us and our chattel paper property and our birth certificates since day one. This is a business for them. And when I say them, let me just tell y'all who I'm talking about. And I don't want to leave nobody out. So let me get my little list, because I got a list that I deal with every day. When I say them, I'm talking about the Bilderberg family, Farnese family, Maxima family, Rockefeller family, Rothschild family, Morgan family, Goldman family, Steinberg, Habsburg, Rosenberg, Cecil, Forensini, Collins, Palavinici, Higgins, Versailles, Rospigliosis. These are the families that have worked together and conspired together to suppress the masses of populations around the world. Okay? This is who I contend with every day. And by the grace of the Most High Creators, I am still here. So that is for a reason. Okay? These people have profited and gained off of the essence of the aboriginals around the world. They're leeches. These people rose to power by being leeches. That's all they are. They're a detriment to society. They are the real menace to society. Those families. Because they cannot exist without extracting something from the masses of the people. And everything that they do is designed to bring harm or extract from the masses of the people. The masses, the inhabitants, the de jure natural inhabitants of the world. Worldwide operation. This is a worldwide operation. So moving on, the definition of preeminence, the fact of surpassing all others, superiority. That's what they think. These Illuminati families, that's what they think they are. Preeminent over others, superior over others. That is because they have held the knowledge, the supreme high knowledge, and kept it to themselves. So yeah, they have been a little bit superior because we if a person does not know what's going on and does not know the full terms and conditions of the business they're in or the engagement they're in, they're going to be a little bit lackluster on the rules of engagement. And that's what's been going on. We haven't been aware. So now that we're becoming aware, we can contend with the powers that be, those that have been suppressing us. We can contend and win. But it is so true that those that do not know will perish for the lack of knowledge. And that's why I'm still a sponge to this day, soaking up all the knowledge I can because it's always something to learn. I don't care how old you get, I don't care how many numbers in age you grow to be. You can always learn something. Here's some definitions right here that case law that deal with Indian, and this was one of the original definitions. Indian was recognized as Aboriginal inhabitants of North America. That alone should let you all know what time it is. An Indian is an Aboriginal inhabitant of North America. Okay? Case Frazee versus Spokane County. 29 Washington Wash. 278 69 PAC. 782. That's a case right there. There are no light, these are my words. There are no light-skinned Aboriginals. They're dark. So when they say Indian, Aboriginal inhabitants of North America. So the word itself denotes who those people are. A common definition of Aboriginals: a noun, an Aboriginal inhabitant of a place. Synonyms: native, Aborigine, original inhabitant, autochthon, indigene, indigenous, first, ancient, primitive, primeval, primordial. Term Aboriginal refers to the inhabitants of the Americas and the world with the darkest of skin, indigo. Like sometimes they used to say, uh, they they're so dark, they're so black, they look purple or something. These are the original inhabitants. These are the heirs to the land, not the amalgamated light-skinned versions that they call Indians today, who came in on the Dawes rolls, the admixture that were created from Aboriginals mixing in with the antiquities, or mixing in with the Inquisitioners, colonialists, which created the latter day Indians. Those were mulattoes. An even larger portion of Caucasians bought their way into the Dawes rolls by paying $5 in exchange for being listed on the census index as Indians. We, the people of the land, Aborigine Moors of America, Aborigine Moors of the world, come now to set the record straight. We do not claim to be Indian. This term originally described Aboriginals of North America. The term Indian has been molested by federal mandates and describes a people that are not true Aboriginals of North America. We claim to be Aborigines of the Americas and of the world. Empress Ninti's nation is Cherokee Moors of North Carolina territories under the Aborigine Moors of a Mexican Great Seal. See the maps. These maps are in some of that have been duly filed for the record, for the public record. Descendants of the Aboriginal Indigo, indigenous inhabitants, Sakim, Sagamores. Look that up. Sakim and Sagamores. Empresses, let me go back. Descendants of the Aboriginal Indigo, indigenous inhabitants, Sakim, Sagamores. Empresses of North Carolina, who predate Indians of today. We are the Aborigine autochthonous inhabitants of the land. So this is one of my documents. That's one paragraph of thousands of pages of documents that I have filed. Going back to this term right here, you all who claim your indigenous status, you need to know what this word is right here. Sagamores. And a lot of indigenous people say, we're not Moors, we're not this, we're not that. They have not done their proper diligence and research. This word shows up everywhere. This is a word. Sakim is a chief. Sagamore refers to the ruling tribe. Sagamores. This is what they call themselves. Indians predate the Aboriginal Indians. They call themselves these terms. Sakim, Sagamores. You see? So those that like to contend with me and argue with me and disagree with me, they know, they haven't gone fully in depth the way I have for as many years as I have. I know what I'm talking about. I know what the ancestors referred to themselves as because I found it. I went through the archives. I go through the archives. I continue to pull up the truth. I dig up the bones. Okay, Joshua 1:3-6, and also Jeremiah 1 and 2. I dig up the bones. That's what my job is. So I know the truth. Case law. Status of the Aborigine Moors of Amexem, Empress Ninti and her indigenous nation, Cherokee Nation of Moors, a status that existed before the U.S., a status that existed before federal agencies, a status that existed before the courts, these admiralty courts, a status that existed that was created before the courts, a status that created Continental Congress, a status that created the courts, a status that granted rights and laws. That's where we come from. Here's tons and tons of case law to support what I'm saying and what is in our reclamation. We have to have that to come out of, as they said, we was gonna have to come out of her. It's coming out of him, coming out of that phallic system, phallic worship system. We have to come out of these indoctrinations that we've been under. So this is what I have placed in our reclamation, and a reclamation is to reclaim status. Reclaim, it's a reclaim action. That's why I spell it the way I do. I put the A in reclamation. Reclaim. We are here to reclaim what is already ours. And the reason we have to reclaim it is because they deemed everything abandoned and turned the maps upside down. So it's hard for many of us to find where our family estate is, where our families were settled. This is why. This is why we were duped out of our land with paperwork. So now you have to do them one better. Let them know that you know who you are, and here's why. And here's the law. This is already decided. These are cases already decided. I'm indigenous to this land. This is my land. I'm considered a sovereign on this land, and I cannot be charged. I cannot have a charge on my own land. If I'm the sovereign, if I'm the indigenous heir to this land, how is a foreign court going to charge me for something? It doesn't work that way. It doesn't work that way. One of the points I make in the reclamation that I refer to, this point was already made, I refer back to rate is that it is that tribes do not waive their sovereign immunity when they fail to object to cross claims in litigation. In Puyallup Tribe Inc. versus Department of Game of State of Washington. That's one case. The court held that a state could not sue a tribe for its fishing regulations in Indian country absent an effective waiver or consent from either the tribe or the United States. There's also case law that indicates it cannot be enforced in Indian country or outside of Indian country. These are some of the things indigenous inhabitants need to know and need to be able to stand on when claiming your status. You have to, unfortunately, fight your way out this status that they have put you in, which is ab asudis non fit injuria. That means that you're not status, so that means you have abandoned it. You have abandoned it. I want y'all to really know this. We have been dropped into this. So now you have to articulately work yourself out of it. Ab asudis non fit injuria, from things to which one is accustomed, or in which there has been long acquiescence. And acquiescence means to go along with something in agreement, whether by contract or by tacit agreement or silent agreement. That's what tacit agreement means, to go along with it silently. You have agreed to it. For our slick, you have agreed to something, but you don't even know you're in it. But by your silence, you're still silent after 150 years. So say like, well, let's keep going with it. Let's keep on smashing them because they don't seem to wake up. So let's just keep doing what we've been doing. Okay? From things to which one is accustomed, no legal injury or wrong arises. So this is saying that they cannot be charged, or no case or nobody can legally say that they have done you wrong because you long agreed to it silently. That's what this means. You have long agreed to what they are doing silently, which then over time makes it the color of law. It makes it a colorable law. It's been going on so long you think it's law, but it's not. Just because it's been going on for so long does not make it law. But here's the catch. This one little nuance, this one little legal definition, which is as old as the Black's Law Book is, and that was written in 1893. Ab assutis non fit injuria. From things to which one is accustomed, or in there has been long acquiescence, no legal injury or wrong arises if a person neglect to insist on his right. He is deemed to have abandoned it. Now, and it's a case law right here. Now, I can remember many times in court, they tried to make me think that what I was, see, it's a game. It's all a game. They tried to make me believe on so many occasions that I did not have them. And I know I did. Just like recently, when I presented my son's tribal ID, Cherokee Nation of Moors ID, which states on there the whole state of North Carolina is reservation territory. They already know that here in North Carolina. The judge, the clerk handed him, pardon me, the sheriff in the courtroom handed him the ID card. And I tell him, this is, he can't be charged for no legal wrong. He's a part of an indigenous nation. And here's his tribal ID card. This judge sat right there and act like he lost it. He sat right in front of me and act like he lost the ID that the sheriff had just handed him. You see where it says insist? If a person neglect to insist, insist on your right. Not tell them, not say, I think I have rights, not act like you don't really know. You have to insist. This is a law. This is a legal thing right here. If you don't insist on your right, I sat there and I would not leave until that man that judge gave me that ID back. I asked him once, I asked him twice. He kept denying it. I asked him a third time, and a few minutes later, he mysteriously found it. Oh, it fell on the floor. They're doing rituals. I had to, and this has happened to me more than one time. I had to ask him 3 times. See, that third time, they always, if you insist, past that third time, past that second time to the third time, they open the door. But you have to know. If you let them keep uh fooling you or tell, they're gonna play the game. It's all theater. It's all theater. They're actors, but they base everything they do on this one premise right here. Ab assutis non fit injuria. If you do not insist on your right, then you are deemed to have abandoned it. So when he denied me the first time and said he lost it, if I would have just been like, oh, okay, and walked out of there, yeah, it's a win for them. That's them um, doing their job. Because every judge, every attorney, everyone who has taken that oath to the British crown under that bar card has agreed to the deception, to lead you astray, to hide the truth from you. And what is the truth? That you are the heir to this land, but you don't know it. Everybody else know it but you. Everybody in the businesses, courts, governments, ruling seats, everybody know this but you. And that's the lie that they agreed to uphold in these secret societies. That's a secret society, the bar card, the judges and the attorneys, um, uh, their little secret society of bar card, British aristocratic registry. All of that's secret. I'm not supposed to know this. Those out there that have this knowledge, we not supposed to know this. That it is a secret coup going on right before our eyes, repeatedly. And the British and the courts in these counties have been hijacked. That's not the proper jurisdiction running those courts. That's why I have to hurry up and get my things and government together here, where I have closed down the court that shall not open back up until it is in the proper fashion, and that I have the proper staff in there that is going to be legitimately fair and not of any kind of secret society or former allegiance to this or to that. Because every one of them that's in those seats right now, I promise you, they have a prior arrangement, prior allegiance agreements that they have taken, whether it be to the United States government, military, federal agencies, or British aristocratic registry. Their allegiance is to something else, unbeknownst to us. That has been the problem. So keep in mind that if you do not assert your rights and insist on them, you can't just assert. This is a legal term. And best believe these judges and attorneys been taught this. If they don't insist, then you know they abandon their rights. Another word they use is waive. You have waived your rights. That's another term they use. If you don't insist on them, then you can forget about it. They're going to play you. They're going to play you because you don't know. And you not insisting upon your rights. That's how they know you don't know. You don't really know your proper stance, your status, and you don't know your rights. So this document can be found on, excuse me, aborigineofamerica.com, empressinamerica.com. Let's see, world notice, world courts, sovereign soil tax. The first sovereign soil tax that I ever issued under the Imperium powers was in year 2014 to President Obama. And it's always issued under our seal, flag, and coat of arms. This is a flag, and it's a coat of arms. What you see today is red, white, and blue banner. That is not a flag. That is not a flag. This is a banner. That's a banner. Anytime you don't see the representation of the land or the people the land is representing, that's a banner. But we don't know this. If you studied war or maritime law, admiralty law, international law, then you know that this is a banner. There are no faces representing the people of the land. So this is not a flag. Okay? And those that know this, they get ostracized. Like Colin Kaepernick about singing and standing up for the Star Spangled Banner. I mean, they tell you what it is, and they say what they were about in the songs that they made us sing in school. Mental slavery is what we've been under. This right here is a banner. It's not a flag. This is a flag. The flag that I've resurrected. And this is a seal. This is our seal. Official seal for the empire. Americanus Empire, which is now the Aborigine Moors Empire. So this document is another world notice that is legally and lawfully binding, written in year 2018, and the fullness of this can be read at the website, on the website. Under the tab, Path to Freedom. This is the Empire of the Aborigine Moors website, EmpressInAmerica.com. Under the tab, Path to Freedom, it can also be found at AborigineOfAmerica.com. Click on Path to Freedom, and there are documents here. This is what we consider our path to freedom. Since the year 2016, when the Americanist Empire was resurrected, we have developed a charter for the Aborigine Moors Empire, issued royal decrees and orders regarding our status and how we should be dealt with, how we should be recognized, and how these governments are to handle us. Dragon. Let's see what this one says. Dragon. This one is a long one. I think this one is like 123 pages, if I'm not mistaken. Yeah. This one is 123 pages. And this is one of the lawful documents, notices that went out worldwide, even to the King of Morocco. Public notice. And it talks about my stance and all of the claims that I have lawfully made under the law of heirs. This public notice is written pursuant to the authorities of heirship and aboriginal claims, law of heirs, doctrine of heirship, aboriginal titles and claims. And please know there's a difference between a title and a deed. I have filed aboriginal title claims and abstract of titles. International commercial claims, King James I, biblical laws, King Charles II, Carolina Charters of 1663 and 1665, His Majesty's Laws of North Carolina, 1739, His Majesty Emperor Muhammad III bin Abdullah al-Khatib of Morocco, Peace and Treaty of Peace and Friendship, 1786, 87, and 1836. These are some of the staples that I used in my public notice. And I put a disclaimer on here. What you will read may be a shock or cause you to have a sense of denial because you have been taught nothing but lies for the past 2 centuries. Rulers of the world and law creators and makers were Moors, never slaves. Your history books have whitewashed their faces. Your ignorance is no excuse. I advise you to do your due diligence prior to any response. I take this time to make a disclaimer because I first am an educator and a historian. I come from a place of love. The matter presented is res judicata, stare decisis, and collateral estoppel. Writ of replevin in action. Now they know what this means. That I wrote writ of replevin. I put a writ of replevin on them in 2017. Okay, that means bring all of it back home. Everything you stole, bring it back home to the owner. That's where your power is, in your writs. You have to command them with a writ. That is the de jure law. All that other stuff, a warrant and all of that, that is just a commercial charge. It's not it's not lawful. It's just um, an instrument written by a corporate fiction. This documentation I'm presenting to you today is not written by a corporate fiction. So a warrant, as opposed to a writ, is a warrant does not hold a candle to a writ. Your lawful remedy is in the writs, not the warrants. Certificate of registration. This is the proclamation. Ancient imperial Moors are out of interregnum as of year 2016. And then here's the abstract of Aboriginal title. Reclaiming all of the land under the title and the doctrine of heirship. So once again, a deed has no bearing on a title. Understand, I want you to begin to understand that a title is an entitlement. That means you have an entitlement to something. A deed is just a piece of paper that's passed on to one from the other, giving no real uh, warrant as to the validity of ownership. It's just a deed showing proof that I passed this land over to you, or I passed this property over to you, and I gave you a deed. I did a good deed by handing this over to you. Just show proof that it's now yours. But none of them really own it. None of them really own the land. They came forth with that Torrens system when they stole the land and regentrified it like they still doing to this day. Moving army vets into the settled neighborhoods or the old neighborhoods of the so-called blacks in these urban areas. But once again, if nobody insists on their rights, you have none. Ab assutis non fit injuria is a legal term that they use silently against you. So I named this abstract of title, aboriginal title, and imperial title as heir to the land. To all men and women, I present this claim. And this has been filed and published to the public since year 2017. The first claim attached to a monetary value against the United States and all its departments was filed in year 2007. That's the first claim and lawful claim that I made against the United States and corporate fiction departments. This is a claim of title in land absolute. There's the term absolute once again. I went over that in the the previous session, part 2. Superior to allodial title, superior to U.S. land patents. Yes, all of you that's just now learning land patents, this is superior to land patents. You can't patent land. They had to do that. Remember when I discussed why they came up with corporations in the first place? So that they could lawfully do business, so they could legally, legal and lawful is two different things. So they could legally do business on the land. The same thing with the land patent. That's how they legally took the land. All of that's fraud. All of it's fraud. Just like putting a patent on a vegetable or a plant. That's what you call a universal a law of nature that cannot be patented. Okay, so where there is an entitlement, there is a title. That's it. Okay, wherefore shall be treated, this abstract of title shall be treated as the most supreme title in whatever jurisdiction that this abstract of title is presented in. If presented within the county records, United States District Court, lower courts, or otherwise, it shall be given the same consideration as a United States land patent. For this is the highest, most superior title known to the United States corporation and courts. This abstract of aboriginal title trumps all. It is supreme and absolute title to the land. So, I took it all back. Joshua 1, 3 through 6. That is my job, to bring the land back to the people of the land that it was promised by our Most High Creators. She will give to us. So, I'm doing my job very well. I'm just waiting on all the heirs to wake up. But the groundwork and the foundation is already laid out. Now know ye that the heir and assign Eureka Micheline Ramjour, also known as Ninti El Bey, now known as Empress Ninti, North Carolina, and now known as Empress of America, is in consideration of my antiquitous ancestral stone monument landmarks, ancestral imperial words of King James, Joshua 1, 3 through 6, and the laws passed down by imperial Moors who have lawful ownership of the lands of Americas, and in conformity with the law of heirs, doctrine of heirship. So this is 123 pages that you can go to the website and read through and learn what I did, and learn how you can also make claims upon your ancestral estate. And please know that in the soon years to come, if you do not make your proper claims, there will be another indigenous inhabitant that will come and make those claims upon lands that you think you own. Because right now you have a bunch of banks that have laid claim to abandoned land. If you don't come forward and do your proper claims in your status, in your persona and in your property, someone else will have their proper status and their proper person in order to be able to take over whatever land that one that has not done that, they can be usurped. I hope y'all following me. Okay? Because the way the law works, in order to be effective, in order to effect a claim, you have to have subject matter jurisdiction and you have to have persona jurisdiction. You have that. You have to have droit droit. You have to have the right of land and the right of property. So that's 123 pages, pardon me, of straight fire. Straight fire. I even showed love to other Moors and brothers who I felt had done some due diligence and contributed to our development. I always show love, but if you see a lot of these brothers, they don't know how to show love or acknowledgement and give credit where credit is. But I see my DNA all over the place. But it's not mine, you know. I just feel like it's once it's gone out into the universe, that's what the ancestors and the most high creators wanted it to be. But if it was the other shoe, it would be a different story. How many of y'all know about Empress Khalifa, namesake of California? Bring her back to the forefront, talk about what she contributed and in her lifetime. Just 123 pages of straight fire. Okay, which president was this? President Obama. Yeah, I've communicated with many presidents since Bush was in office, 2007. Just went to the president, his executive building, his executive offices, and I also discussed the speech that Pope Francis made. This was after a royal decree, a mandate that I sent in to the Vatican and to the president. And a lot of his verbiage had indicators that he had read the decree. And this was to President Donald Trump. Okay, I see what I did. I made reference to um, Obama when Trump first came in. These are some of the monetary claims that have been made that are still on the books as credit that are being used by the North Carolina Department of Insurance. That's where all of the monies are being traded, the instruments are being traded, the bonds, the birth certificates, warrants, 1099s are being traded through that entity. When it comes to the county register of deeds instruments and the courts instruments. So be sure to go over to empressinamerica.com and see the steps we have taken to the path of freedom. This has been another episode, another impactful, informative episode of bringing back and resurrecting the empire with Empress Ninti El Bey, the Godmother. I will be back with part 4. Stay tuned. Peace and love, family. And again, thank you for your time. And thank you for watching. Be sure to share. Be sure to share this video with your family and friends that you think might be knowledgeable in these subjects or just need to know. These are really things that we should be sharing with everyone so that we can get the word out about our status and our land and that it is back in the de jure form of government. Ashe. Peace and love. See you on the next one.